Now, the Constitutional Court has confirmed that the Matrimonial Property Act 88 of 1984 is unconstitutional and invalid. Now, this is the ruling, of course, made by the Constitutional Court after an earlier one that was made in 2020 by the Durban High Court. Now, prior to 1988, legislation in South Africa stipulated that black couples in civil and registered unions were automatically married out of community of property, except under special circumstances. Now, the original act was repealed in 1988, but did not apply to marriages that took place before that time. Well, to expand more on the significance of this Constitutional Court confirmation of the Durban High Court ruling and what it means for thousands of black women in South Africa, I'm now joined by legal expert Nthabiseng Dubazana here on the Midday View. Nthabiseng, good afternoon. This is a very significant confirmation by the Concord of that Durban High Court ruling of earlier. It's a very big decision.
Yes, it is, because one of the things that was requested from the Constitutional Court by the appellant, who was the wife in this matter, was that the declaration by the Durban High Court must apply retrospectively, which means it should include also the current marriage, which is her marriage, and all marriages that still exist as a result of this act. So which means everybody now that was married before 1988, now they are now automatically married in community of property.
And that means, and being married in community of property brings with it certain rights that those women were denied.
Yes, 100%. So rights in property, rights in the entire estate as a result, and rights in terms of succession, in terms when the husband would die, they won't be left destitute anymore, because now they wouldn't. Before they didn't have rights over anything. So if your husband were to die, then you basically left homeless, penniless, and all of that. You had to basically start from scratch. So now that has changed in its entirety. So when the husband dies, or there's a divorce, or whatever the case may be, the wife now has a claim on the combined estate of both parties.
Yeah, because previously, under the apartheid era racist Matrimonial Property Act, women were being unfairly discriminated against. They would get married. Some of them, like in this case where this lady took this to the Durban High Court and subsequently to the Constitutional Court, the husband, when they were separating, wanted to sell the house and keep the house and keep the proceeds for himself. And she was opposed to selling their home and saying she wanted to keep it, but she thought she was married in community. But the old law made her automatically out of community. Now that has changed.
Yes, 100%. So now the husband, remember, was challenging that the decision of the Durban High Court should not apply retrospectively, which included in the current marriage that he was now in with the applicant, or the applicant to the Constitutional Court. So now what he wanted to happen was that he must continue to sell the property because it's his solely. It is not part of the marriage regime. So now what happens is that he has no way of selling the property anymore, because now they're now married in community of properties. If a sale is going to happen, then the proceeds will be divided between the two parties. But if the applicant, which is the wife, doesn't want to sell, like is the case in here, then she can now buy him out of his share, and then she can have sole ownership of the property.
Now, it's one case. Now the Durban Court ruled, the husband challenged it in this case, and the Constitutional Court now confirming that it is so, it applies retrospectively. Practically, this was going to affect many marriages that may have come and gone. If people are still around and their rights were undermined, or they didn't exercise their rights because the law, can they claim now? Will it open floodgates for claims?
Yes, I think it will be able to open the floodgates rather for claims. The only issue that I think might be a problem would be if the divorce is already granted and it was based on the fact that the parties were married out of community of property. Perhaps now they can go and approach the court and say that, and ask for a variation of the divorce decree. So that could be possibly what they could look for. But otherwise, the marriages that are still in existence right now, they can be confident to say that now they are now married in community of property with their spouses. And perhaps maybe just to make it even safer, just go and apply to the court and change it legally onto the system and all of that to be of marriage in community of property in terms of Section 21, I think it is, of the Matrimonial Act. So they can now go there and then change it in that way, so that tomorrow, if they do decide to divorce, then it is already on paper that they're married in community of property, and they can use this case as a reason to change the marriage regime to one from out of community of property to one in community of property.
Nthabiseng Dubazana, as usual, thank you very much for your legal insights and expertise there in this groundbreaking constitutional court decision. In case you've missed it, the Constitutional Court confirming just the other day a Durban High Court ruling of 2020 that is repealing the Matrimonial Property Act 88 of 1984 as unconstitutional and invalid, and applying it retrospectively to all marriages that included black women who were discriminated against before 1988.